Mr. Mellor, we're going to turn in a second to your time as Chief Secretary to the Treasury.
Yes.
Before I do, and just to provide a bridge between where we were and where we're going to be, in November 1989, as we mentioned earlier, the Mcfarland Trust received further funding, which ultimately amounted to some £24 million, principally to fund a non-means tested payment of £20,000 per applicant. And if we think back to the document that we were looking at just before lunch, that seems to be an amalgamation of options B and C. So it's not as if nothing was done, but options B and C seem to have been taken forward. We will also, sir, be hearing from Lord Waldegrave and Baroness Bottomley in due course, and they will be able to give evidence of what their thinking was. And of course, we've already heard from Lord Clark on those and related matters. Let's turn then to November 1990. So we have come forward in time just over a year. Another significant period of change politically. Margaret Thatcher had left office. John Major had become Prime Minister, having previously been Chancellor. The former Chief Secretary, Norman Lamont, had been promoted to Chancellor, and you took over as Chief Secretary from Norman Lamont. Also to note that a few weeks before, William Waldegrave had taken over from Kenneth Clarke as Secretary of State for Health. The wider political context, and you mentioned this in the statement, is that this is the period seeing the lead up to the Gulf War, which was obviously the dominant political theme at the time.
Yes.
Could I ask you just to give a very brief overview of what the role of Chief Secretary to the Treasury entailed?
Well, the Chief Secretary is in charge, basically, the government's bank account. And the Chief Secretary exists within the Treasury, but has a separate remit within the Treasuries. And that remit is to hold hearings with every department about their spending plans and to adjudicate on their spending plans and to determine whether or not their spending plans are reasonable or not. And over that, Cabinet having agreed to what the expenditure plans should be in the year, to try to cut and paste and make sure that that those spending plans, each department's spending plans, fall within the overall package. And you won't be surprised to know that a lot of people who enthusiastically agree to the targets in Cabinet lose their enthusiasm when they're asked to say what their own department wants to spend. So I mean, I would say of all the jobs I did, it's certainly intellectually the most rigorous and toughest, because you've got to be across every department's expenditure. But equally, it's fair to say, the Treasury tends to attract the cream of officials. And in fact, I don't know whether I said earlier, but my private secretary for most of my time in the Treasury, Jeremy Hayward, who of course went on then to become the head of the civil service, sadly died of cancer very prematurely. It was a great loss, not just to his family, but to the cause of good government in Whitehall. With that quality of person, you had very few excuses for not being on top of the job, but it was still a struggle.
And we should understand, shouldn't we, that the issue that we're going to discuss, the settlement of the Hiv litigation and then the extension of payments, that is one small part of the work that you were doing at that time as Chief Secretary. I'm
afraid that's true. And also, you mentioned the Gulf War. Because of my connections with the Gulf, I was also had to, in the early stages, to go out to the Gulf quite a lot and collect money for the war effort. It led to some endearing encounters with one Gulf leader who had been told what I wanted. He said, "You know, I often feel we don't show our respect enough for the help we get from Britain. So I was just thinking, would $500 million be good for you?" And I said, "Very good, yes." And I forget, we're talking 30 years ago. But those journeys, which, you know, I wrote that minute, not in a different context, but it was a very turbulent time in the Gulf, and because it was regarded as an expertise of mine, I did spend quite a lot of time doing that sort of stuff. But that took me away from some of the other things I should have been doing.
I've just got a few general questions about how the relationship between the Treasury and specifically the Department of Health work.
Yeah.
You have said that the Chief Secretary and the Treasury were involved in setting the overall figure for an annual budget for the department. Once that was set, did the Treasury have any say in how that money was going to be spent?
Oh, yes. The Treasury would not only have a say in them spending what they were allowed to spend in terms of continuing to approve it, but there was also the reserve. And, of course, a lot of departments like to raid the reserve, and we've already heard a bit about that with the territorial departments and their desire to have to claim the cost of the lawyers sorting out one or two of these things in these settlements paid for. So you had to keep an eye on. Yeah, I mean, no department ever thought they had enough money. That was broad. And if they could find a way of chiseling a bit more out, they would. But that's human nature, you know. So Eric Roll, who was one of the best civil servants in the Treasury after the Second World War, said spending ministers are like the elephants. They come down to the waterhole in the evening and you drive them off, but the following morning they are back.
Your reference to the reserve there is to the Contingency Reserve, which is,
yes,
as I understand it, the money that was held by the Treasury in reserve in case it was needed.
In case, and sometimes there are, dramatic reasons why you need a reserve. Unexpected things happen. But sometimes the expected things happen, which is people haven't made proper provision for what they've got to spend, and they use any pretext to go into the reserve. And of course, it's very easy to say yes, but the worst thing you can ever do in the Treasury is to say yes, because there's never an end to it then. You've got to actually try and maintain some sort of discipline. And some departments are much better than others in terms of their ability to apply rigor within their own negotiations, so that when they come to negotiate with the Chief Secretary in the public spending round, some departments have a reputation for just trying to get anything, and others are known to be rigorous. And the same is true of ministers. And one of the reasons why I think Kenneth Clarke has always enjoyed such a high opinion of him, certainly with the Treasury, was that even when he was Health Secretary, he did his best to not put to the Treasury things that he hadn't rigorously argued out with his officials. So he was regarded as credible. Not everyone who was in that department was.
On the reserve, you say in your statement, at paragraph 6.11, that it's at page 49, that it was carefully guarded, and that access was only allowed to departments when there was no alternative.
Yes.
So,
but we're talking about ancient history now, you see, sadly. But not because of anything particularly that I did, but during my time as Chief Secretary, all I had to do was try and make sure not too many cats escaped from the bag. The percentage of national wealth that was spent by the government was the lowest ever. I mean, I think people need to take a pretty strong heart pill before they look at what it is today. Because at the end of the day, if the Treasury isn't rigorous or allows excuses of things that have happened to justify extreme spending, then there's trouble. And, we're not going to stray into contemporary issues now, but there's a lot of trouble at Mill so far as the government and the Treasury are concerned at the moment, because they need more money and they haven't got it.
Just finally on the reserve, as you say, it has to cover the whole of government, all of the departments.
Yes.
And if it runs out, then
then you've got a problem. I mean, it never quite runs out. You can always borrow some more money, and plenty of people who've done that. But generally speaking, there is no job satisfaction in working in the Treasury if you don't have a goal and try and achieve it, you know. There's got to be some belief that what you're doing is important, and then there's got to be some determination to do it.
one final question on these general points about the relationship between the departments and the Treasury. Could you explain the significance of the financial year and any sums that are left over at the end of the financial year?
Yes. That isn't always, I think, Whitehall at its best, but notionally, if you're allocated money and then you don't spend it, you lose it. And that's not always a very good idea, although the Treasury can actually require, not just as a global sum to be spent, but they can require proof that what was spent on the purposes for which it was allocated. But there's a good example of that we'll come to about where money that was allocated for 1 year couldn't be spent in that year and was going to have to be spent in the following year, where technically you have to go back in and bid for it again. You can't just say, oh, well, all right, I can't spend it this year. Let me keep it for next year. And the answer to that is always no.
Similarly, if a claim is made on the reserve in year one and that money is not spent, is the expectation from the Treasury that the department will just have to budget for that in year two?
Yeah, exactly right.
Let's turn then to the settlement of the HIV litigation. If we could have on screen, please, HMTR 602_011. It's page 37 and 5.3 of your witness statement.
Yeah, thank you.
This is a memorandum, or a minute, sorry, that was sent to you by AJC Edwards.
Yeah.
And we can see to you, Chief Secretary. Could I just ask who Mr. Edwards was?
Well, you can ask. Isn't it terrible? I know who the Chancellor was, and Sir Peter Middleton remains a good friend of mine. He was the Permanent Secretary. But no, I'm sorry, you've caught me out there.
Is it fair?
But he would have been a very senior official. But with the best will in the world, it's always hard to remember all the names down the... he would have had to be very senior. Yes.
That was going to be my next question. Let's read through this minute, and we note that it's sent on the 29th of November 1990,
yes.
Which would have been, I think, the day after that you had been appointed.
Mm.
So one of the first things in your inbox, as it were. It says HIV-infected haemophiliacs litigation.
Yes.
As you will recall from an earlier incarnation, the Department of Health and other government bodies are to be sued in the High Court by representatives of the haemophiliacs who caught the HIV virus from contaminated factor VIII injections in the early 1980s. The case is due to begin in the middle of March. Counsel for the haemophiliacs, Hugh Evans, has now told DH's counsel, Andrew Collins QC, that he would be prepared to advise his clients to settle for payments totalling some £42 million. Ministers need to decide how the government should respond.
Yeah.
Mr. Waldegrave, just as a reminder to everybody by now, the Secretary of State for Health, has asked to discuss this with you in the next day or two. It will be necessary to consult the Chancellor and the Prime Minister as well. The passage of time since DH's receipt of Council's proposal on the 9th of November and the mounting costs of legal preparations both argue for an early response.
Yeah.
Background. At least 1,200 haemophiliacs became infected with the HIV virus as a result of injections of factor VIII clotting agent made from contaminated blood between 1981 and 1985. The government has never accepted legal liability for this great tragedy. The government's position has been that AIDS and its transmission were not understood at the time, and there was therefore no fault and no liability. The virus was not finally identified and isolated until 1983. Heat treatment to make blood products safe was not discovered until 1984 and was not introduced in England until April 1985, though Scotland was able to introduce it earlier in December 1984. The United States had introduced it in September 1984. In response to requests from the Haemophilia Society, the government set up the Mcfarland Trust in 1987 with an initial endowment of £10 million to be paid from the infected haemophiliacs on a discretionary basis. If I just pause there, we can see that there's some handwriting on the document.
Yeah.
If we, I won't go back to it, but on the first page it says, there's the same, written in the same hand, it says, please ignore the scribbles. I thought I was being asked to look at a draft. So whoever, is that your handwriting? Or
No.
So
And it's far more readable than my handwriting, yeah. Public pressure led by instead of requests from, yes.
But I would ask you to ignore the handwriting for that reason. What you would have seen may well have been the document without that handwriting. Last year, the government agreed, going back to the document, last year the government agreed after discussions between the Prime Minister, Mr Clarke, and the present Chancellor, Norman Lamont, to provide a further £24 million to finance non-discretionary payments of £20,000 to each of the 1,200 then known sufferers. I pause there to say that's the payment that we were just discussing. These payments were likewise administered by the Mcfarland Trust, though for technical reasons they were channelled through a separate trust. The haemophiliacs representatives decided nevertheless to bring proceedings against the government in the persons of the Secretary of State as the Licensing Authority for Medicines, the Department of Health, the Committee on the Safety of Medicines, the Central Blood Laboratories Authority, responsible for the Central Blood Products Laboratory, manufacturers of Factor VIII, and regional health authorities. There are likely to be around 30 plaintiffs chosen to cover between them all types of cases. The next development was that the trial judge, Mr Justice Ognall, issued in June, and we take this to be June, well, we know this to be June 1990, so after you had left the Department of Health and at the time you would have been at the Home Office. The next development was that the trial judge, Mr Justice Ognall, issued in June, most unusually, a statement which implicitly recognised that the plaintiff's legal case was not strong, but urged the government not to take a narrowly legalistic view, but to explore the possibility of settling out of court. After discussions between Mr Clarke and the present Chancellor, the Department of Health wrote back to the judge rejecting his appeal for an out-of-court settlement. The letter drew attention to what the government had done already through the Mcfarland Trust. It also made the points that total resources were limited and that many other groups of people suffered similar misfortunes. This response was sent on the 3rd of October.
Yeah.
Forgive me, I've just... the haemophiliacs representatives made overtures later in the month for a negotiated settlement. The present Chancellor and Mr Clarke discussed the matter on the 23rd of October. So I pause there to say that is a reference to Mr Lamont, who
was then Chief Secretary.
Exactly.
Yes, he was in his capacity as Chief Secretary.
Then Chief Secretary talking to Mr Clarke, then Secretary of State for Health, on the 23rd of October. Mr Clarke suggested that if the other side made an offer of £20 or £25 million, and the Department of Health lawyers considered that it included a watertight guarantee that the writs would be dropped, this would present a good settlement. The present Chancellor, again Mr Lamont, expressed the view that a settlement at that level was highly unlikely. He felt it would be far more satisfactory to win the case in court and then make a moderately generous offer on an ex gratia basis. The present Chancellor and Mr Clarke agreed that the government lawyers should be instructed not to make an offer themselves under any circumstances. As noted above, counsel for the haemophiliacs has now told Department of Health's counsel that he would be willing to advise his clients to settle for payments totalling some £42 million. Individual payments would be tailored to personal circumstances and would be paid over through the Mcfarland Special Payments Trust. A copy of Council's proposal, which reached Department of Health on the 9th of November, is attached. I pause there just to say, to try to summarise that. The position was that the Department of Health wouldn't make any offers, but when the offer came from the plaintiff's side, it was then considered.
Yeah.
Legal advice, going back to the document, paragraph 13. The earlier legal advice from the Solicitor General and Andrew Collins, as reported to us, was that with limited exceptions, the government did not seem vulnerable to charges of negligence or other fault. The government seemed likely, therefore, to win most of the cases, though judges were likely to be as sympathetic as they possibly could be to the plaintiffs. In a small minority of cases where the haemophiliacs had become infected at a late stage, the chances were perhaps 60-40 in the government's favour. As the date of the trial has approached, DH's legal advice appears to have become more cautious. Their legal advisors now see the plaintiff's case as falling into three broad categories. 1, between 20 and 30 cases where medical negligence would be quite likely to be established. 2, a minority of further cases where infection is likely to have occurred at the end of 1984 or in 1985, where the chances of success on legal grounds were more like 60-40, and 3, the majority of the cases where the legal case looked strong, but judges would do everything in their power to be as favourable as possible to the haemophiliacs. A further problem, as DH now sees things, is that the dividing line between categories 2 and 3 above would be somewhat arbitrary. There was room for debate on the date by which health authorities ought to have known better than administer untreated factor 8. In addition, the dates at which individual haemophiliacs actually became infected could, in many cases, not be established with certainty. DH now seems to fear that, on a very unfavourable construction, the minority cases at 2 above could rise to around 500. Our own legal advisor, while confirming our impression that the DH's legal advice was likely to err on the gloomy side, has noted the risk that the judge might seek to extend the common law in this area along the lines that it has already been extended in areas such as loss adjustment for insurance. A second change on the legal side is that the Department of Health lawyers now put the costs to the government of letting the case proceed at not less than £20 million. This represents an average of £5 million each for all the main parties to the cases: the plaintiffs, through legal aid, the Department of Health, the Committee on the Safety of Medicine, and the RHAs. Our own legal advisor's impression is that the £20 million figure is extremely high. We've asked the Department of Health for a full breakdown and justification. Comparative costs of litigation versus settlement. In the light of the Haemophiliacs Council's proposals and the latest legal advice, the costs and risks in letting the cases proceed as against an out-of-court settlement now look to us to be more finely balanced than before. The Department of Health's assessment, see note B on the next page, is that an out-of-court settlement would cost around £50 million, comprising £42 million proposed by the Haemophiliacs Council, an extra £3 to £5 million for medical negligence cases, which DH would likewise plan to settle out of court, £2 million for costs, and, say, a further £2 million for additional cases not yet known. We will come back to this page, note B, in a second. We could go to page 6, please. Letting the cases proceed, on the other hand, would be likely to cost some £30 to £40 million, according to the Department of Health estimates, in a best case outcome, or perhaps £170 million in a worst case outcome. Department of Health officials clearly believe that now the gap between the best case outcome and an out-of-court settlement has fallen to some £10 to £15 million on their estimates, an out-of-court settlement must be the preferable option. They emphasise the considerable risks that the best case outcome from a litigation would not in practice be achieved, and all the bad publicity for the government over an extended period while the litigation continued. Our view, as noted above, is that the arguments are more finely balanced than before. That said, we do not think that the difference between an out-of-court settlement and the best case court action outcome will be as small as DH suggest. Their comparative figuring assumes that settlement would be reached at the £42 million figure for the main cases, and that legal costs would be no less than £20 million if the cases are allowed to continue. Our own guess would be that allowing the cases to continue and obtaining a best case outcome might cost about £25 million less than an out-of-court settlement. If the out-of-court settlement figures were bid upwards from £42 million, moreover, the difference could, of course, be much greater. Case for out-of-court settlement. We would see the advantages in an out-of-court settlement and the risks of continuing the litigation as follows. 1. Reasonable settlement proposal. The settlement proposed by the Plaintiffs' Council, though expensive and generous by international standards, is considerably more moderate than it might have been. As the table on page 1 of the proposal illustrates, individual people would not get much more than £20,000 each the larger sums being reserved for plaintiffs who are married and married with children. The average payment, allowing for all these cases, would be some £35,000 per head, on top of the £20,000 plus already paid out from the Mcfarland Trust. 2. Risks of High Court settlement. Although there is less clarity than one would wish, the legal advisers clearly see a non-negligible risk that the court cases might be lost badly, with high settlements which would set bad precedents. If the government did lose badly, ministers would probably find it exceptionally difficult to appeal. 3. Invidious borderlines. If the court found in favour of a significant minority of the plaintiffs and awarded them large sums, the contrast between the lot of these and other plaintiffs would be highly invidious. Ministers would come under great pressure to generalise the awards to other sufferers. 4. Bad press. There has so far been virtually no public sympathy for the government's position on this case. The government would... Sorry,
I just said there's a surprise.
The government would have therefore to reckon with the probability of continuing bad press over an extended period from March onwards while the trial continued, and perhaps beyond. 5. Sustainability. If ministers see a strong probability that they would have in practice to fall back on an out-of-court deal at a later stage in the proceedings, it would arguably be better to conclude such a deal at the outset. A case for allowing the litigation to continue. We would see the advantages in letting the case continue and the risks in an out-of-court settlement as follows. 1. Legal position. Despite their concerns, the legal advisers do still appear to see the government's legal position as being very strong for most of the cases. 2. Precedents / knock-on effects. An out-of-court settlement risks setting damaging precedents in the sense of nudging the system towards non-fault compensation and encouraging other groups of unfortunate sufferers to sue the government in the hope of obtaining generous out-of-court deals. People who have been infected through blood transfusions are an obvious case. 3. Dangers of a public auction. We see a considerable danger that the government's willingness to settle out of court, the £42 million proposed settlement figure, would leak. There could then be a public bargaining negotiation in which £42 million would be seen as no more than the government's opening offer, and public sympathy would be with the haemophiliacs. 4. Residual litigation. We are also concerned about the danger that a minority of haemophiliacs might decline to accept the proposed out-of-court settlement and pursue their cases in the courts instead, in the hope of ending up with better deals. If that happened, the government would pick up the legal costs through legal aid, as well as incurring heavy expenses itself. If the cases were successful, moreover, the government would come under strong pressure to increase the earlier out-of-court settlement. Public expenditure consequentials. If ministers do decide to go for an out-of-court settlement, we would have, I think, to accept that most, if not all, of the £50 million or thereabouts of funding required would have to come from the reserve, probably this year. This is regrettable but unavoidable. We would think it reasonable, however, to ask Department of Health to absorb the costs of any settlement in the 20 to 30 medical negligence cases, provisionally put at some £3 to £5 million. Regional health authorities took over responsibility for medical negligence costs from the 1st of April 1990. Conditions for an out-of-court settlement. As implied above, the strength of the case for pursuing an out-of-court settlement excuse me. As implied above, the strength of the case for pursuing an out-of-court settlement turns on how effectively the Department of Health could deal with the risks involved, not least those listed above. We would think it important for Treasury ministers, if they are prepared to contemplate such a course, to insist on the following points. One, no government commitment at the outset to the £42 million figure or any other figures, lest it be seen as an opening offer. 2, a clear understanding between the Treasury and the Department of Health that that £42 million, plus the negligence cases, is as far as we are prepared to go. 3, Department of Health to complete as soon as possible, if they have not already done so, for drafting of the terms on which any willingness to settle would be made. It will be crucially important to avoid any admission of liability or any suggestion of no-fault compensation, while emphasising the unique circumstances of the present cases, including double jeopardy, and possibly the government's willingness to allow for a small risk of losing a minority of the cases. It's labelled as 6, but I think it's supposed to be 4. Any government offer would need to be the subject to the proviso that 100% of the haemophiliacs would accept it to avoid the risk of subsequent court cases. 5. Department of Health to assess and minimise the risks that any haemophiliacs who did not accept the deal, for example, haemophiliacs not previously known or a handful of troublemakers, would have access to legal aid to pursue cases against the government subsequently. 6. Access to be allowed to the reserve this year for most of the settlement, but not for the £3 to £5 million medical negligence element. Tactics on response to Haemophiliacs Council. Further to point 1 above, the government might in principle respond to the Haemophiliacs Council's offers by making a lower counter-offer below £42 million. The problem with this is that a significantly lower offer will reduce the sums per head below £20,000, and DH's legal advisers have suggested that the courts, who would be asked to endorse an out-of-court settlement, would probably not regard this as reasonable. A further problem is that haggling over the figure would increase the risks of a public auction. A better tactic, which you might like to commend to Mr. Waldegrave, if you wish to go down this route at all, might be to avoid any commitment to a figure in responding to the Haemophiliacs Council, but simply to say something along the lines, quotes, "The government is not in the business of answering hypothetical questions and wishes to know whether Council's clients would back his proposal." On this approach, the fact that the government was not explicitly rejecting the Haemophiliacs Council's proposal would give a certain signal to the other side. At the same time, the government would not have committed itself to a figure which could be regarded as an opening offer. In any subsequent bargaining, the aim would be to establish Council's figure as a kind of arbitrator's proposal. Conclusion. If the Chancellor is content, you may like to listen to what Mr. Waldegrave has to say and, subject to that, explore the pros and cons of a possible out-of-court settlement with Mr. Waldegrave along the lines sketched out above. If you feel as a result of your discussions that the balance of advantage lies with pursuing an out-of-court settlement, preferably along the lines and subject to the conditions suggested in paragraphs 26 to 28, you may like to suggest that if Mr. Waldegrave minutes for Prime Minister, you will stand ready to write in support. That is signed by A.J.C. Edwards. Am I correct to read that as being a document which, of course, sets out the pros and the cons of the issue, but is broadly supportive of accepting the settlement?
Yes.
And was this your first contact with the HIV litigation since you left the Department of Health? Was there at the time, or is there now, anything in that assessment that you disagree with?
No, I think it's been, in terms of a Treasury assessment, it's far more open-minded than you would habitually get. The Treasury often, because they're under pressure all the time, will take a very negative view of any proposal that's put to them, but this is not negative. This is actually, I would say, sensitive to all the various nuances, leaves ministers to make their own minds up, but I think it is appropriately tilted in the right direction and responds to stimuli in the right way, which to me the most significant one is that, I don't know whether you ever knew Harry Ognall, but a serious High Court judge like him, given the indication he did, was a sign of just how wound up people within the process got about what was happening. And, anybody who wanted to go on ignoring those signs was foolish. Now, sometimes the Treasury feel they have to do that because that's their role. But I thought that was a pretty masterly set of arguments, and it got the anticipated outcome, and an outcome which I thoroughly agreed, of course.
Had your personal views on what to do with the litigation changed at all since your time?
No, I would have settled it earlier if I could have done. but I was away for that period of several months. And as it happened, I think that while those of us who really wanted to settle this were a minority at the beginning, I think it had steadily become what I would call a sensible view held by a lot of people.
The document shows that various Treasury officials seem to think that the Department of Health were being a little too pessimistic about the costs of the litigation of the legal prices.
It's a bit like, I don't know, if you sit in judgment on football teams, there are some you think are well managed and some you think that are not. Some you think will need an empty net and still won't score, and others who are capable of doing weird and wonderful things with the ball. The Department of Health is, well, what can I say? The Department of Health is not particularly highly regarded by the Treasury. It's regarded as a department that would much rather say yes than no to the various groups that come to them for funds. And so they're not going to get the benefit of the doubt, at least not in my time, from Treasury officials who are pretty battle-hardened, you know. They're not as badly regarded as the Department of Transport. They're in a league all on their own. But, you know, they were not a department that people would say, well, of course, if the Department of Health say that, better take it seriously. They were much more likely to say, well, they would, wouldn't they?
But in terms of your personal view, having served in both, am I right in thinking that your view on the litigation was by that stage fairly settled and so it wasn't going to be swayed?
No, I was completely against the idea of this thing going for litigation. See, the thing about it is, there's no point in going for litigation unless you're totally determined, come hell or high water, you are not ever going to change your mind. No one could say that faced with this. It's just impossible. And I think if you're going to have to make a payment and do the right thing quickly. Why? You know, all this business about letting it run on for a bit. I mean, how much does it cost to let it run on for a bit? You know, it's ridiculous.
There was a further document that was provided to you on the 3rd of December. I'm not going to go to this document primarily for reasons of time. The reference is HMTR 602_014, and it's at paragraph 5.15, page 40 of your statement.
Yeah.
It's from Mr. Saunders in the Treasury, and it is said to be an addendum to the other documents. The briefing that Mr. Edwards had provided you with. Having said I'm not going to go to it, actually there is one section because it's the table of international comparators that you raised earlier. HMTR 602_014, page 2, please.
Oh, this is where we get my table of international comparisons.
So but for completeness, let's quickly look at that. So this is information being provided to you as Chief Secretary, showing the compensation payments or ex gratia payments in different countries. We can see that compensation payments of £60,000 have been paid in Canada. In Germany, £27,000. The average of ranged up to £165,000. France, £10,000. And then ex gratia payments, Denmark, £20,000 to £25,000. Norway, £2,000. Ireland, £9,000. Australia, £7 million in total. And the UK, £20,000 at that time, but obviously under contemplation with a further sum to end the litigation. I should say that the same document also refers to the inevitability, as it was seen there, that any further payments would have to be disregarded for social security purposes.
Absolutely.
Which was in fact done. And then also refers to some of the other cases which affected the ring fencing of any settlement, particularly for Benson.
Yes, so there was no clawback, effectively.
We can take that down. Thank you, Lawrence. The arguments about the dangers of no-fault compensation coming in through the back door, as it were, through this litigation, were raised with you by officials. You say in your statement, 5.20, page 42, I quote, "I cannot recall being particularly concerned about this at the time."
No, exactly.
Why weren't you concerned?
Well, because I just have always thought, I mean, even if one's consistently wrong, at least I've been consistent. I've always believed that the AIDS blood products situation, anyone with any capability to argue should be able to make a clear distinction between that and almost anything else. And I therefore never was worried about it setting a precedent. It's always the argument in Whitehall about why you can't do things. It would set a precedent, and they paint the terrible consequences of setting a precedent. Well, they did in the end set a precedent. There were no terrible consequences to it because it stands so much out on its own. I've always thought myself that the particular circumstances of the haemophiliac AIDS situation was just so awful that, the fact that someone would fill themselves full of tranquilizers is not the same thing at all.
I'm not going to take you through all of the other briefing notes that you received, but I will just flag for the transcript that at HMTR 602_017, it's also paragraph 5.21 of your statement, there was a further briefing from Mr. Edwards on the 6th of December 1990, ahead of your meeting with Mr. Waldegrave. I would point out that deals with a number of notes provided by the Department of Health to assist the Treasury's understanding, including in respect of legal aid. I don't need to take you to that, but it explains the position about what would happen in terms of legal aid, which had been raised in Mr. Edwards' previous briefing. You met on the 6th of October with Mr. Waldegrave. We don't have the minutes of that meeting, but we do have the minute that was sent by Mr. Waldegrave to the Prime Minister. And it's clear from other documents, which you refer to at paragraph 5.28 of your statement, that the Treasury had some involvement in briefing this. The Treasury had some involvement in drafting this minute that went to the PM. Can we have that minute on screen, please? It's HMTR 602_019.
Yes, I mean, this was an agreement between him and I that effectively we were jointly minuting the Prime Minister, approving what was said.
If we could go to the next page, please. That's just the covering minute. Prime Minister. So this is from Mr. Waldegrave, but as you say, in effect, a joint minute between you and him. Prime Minister, haemophilia litigation. I minuted you on the 5th of December about the current position. I was able to go through the issues in detail with the Chief Secretary yesterday evening. We examined in particular the proposal put forward by the Plaintiffs' Counsel. The conclusion was that, provided that the plaintiffs would commit themselves to accept their counsel's proposals, we should be prepared to accept it. Our best estimates, as in Annex A attached, the costs of such a settlement, £47 to £51 million, including £3 to £5 million for medical negligence cases, would be higher than the most favourable outcome from fighting and winning the case, £25 million to £40 million, but much lower than the cost of fighting and losing the case badly. Our counsel have put the risks of this at between 1 in 3 and 1 in 6. It would also be likely in practice to be cheaper than fighting and losing a significant minority of the cases, or fighting initially and settling out of court later. I therefore spoke to our leading counsel, Andrew Collins, and asked him to sound out the plaintiff's leading counsel, Rupert Jackson, on whether the settlement he had proposed would stick. There was no question of our negotiating any higher figure. Andrew Collins has reported back that point 1, Rupert Jackson believes the proposed settlement would stick and will advise the plaintiff's steering committee to accept it. 2, in Rupert Jackson's view, the longer the affair continues, the more difficult it will be for him to get the agreement from his clients. Andrew Collins discounts much of this, but believes there is something in it.
I should just say, by the way, I was at the University with Rupert Jackson, had a very high opinion of him, and so what he said was influential.
And Rupert Jackson was the lead counsel for the plaintiffs.
He was leading counsel for plaintiffs and ended up in Court of Appeal, of course.
Yes.
Yeah.
The Chief Secretary and I believe that we should not pass by a possible opportunity to settle this very difficult issue. We are coming under increasing pressure to settle, not least from our own backbenchers. Settlement now would enable us to avoid the long drawn-out court cases beginning next March, in which public sympathy would be with the haemophiliacs. It would also strengthen our position in dealing with Rosie Barnes's private member's bill on no-fault compensation. The amounts payable per person, as shown on page 1 of Council's proposal attached, would not be publicly regarded as overly generous, though the plaintiffs have, of course, received £20,000 each or more from the government already. We think it would be better to settle on the figures proposed by the Haemophiliacs Council if his clients support him than to bargain publicly for lower figures, which would carry the risk of sparking a public auction in which the government would receive little credit and could end up by paying more. That said, we should clearly need to handle our response with the utmost care. Some points to which we attach particular importance are: 1, we must not go beyond the £47 to £51 million figure, which looks generous by international standards when added to the earlier payments from the Mcfarland Trust. 2, recipients of the new money would have to undertake to drop the existing cases and forswear bringing any future cases on the matter. 3, all the plaintiffs would need to accept the settlement, though we may have in practice to relax this a little. The medical negligence cases would have to be identified for settlement out of court in accordance with agreed criteria. 4, plaintiffs' counsel would need to advise his clients that the offer provided a reasonable basis for discontinuing the court action. This advice would be passed on to the Legal Aid Board, which should in practice prevent legal aid for any resumed action. The terms in which we 5, the terms in which we formally accept the settlement and the basis in which it was put to the court would need to be carefully considered with our legal advisors so as to minimise difficult precedents for the future. In seeking to make our conditions stick, we have an important card to play. The plaintiffs want the agreed sum to be paid through the Mcfarland Trust and so not be taken into account for social security purposes. I have discussed this with the Secretary of State, presumably the Secretary of State for Social Security, who agrees that this should be done. He also agrees that social security payments should not be recovered from the settlement as they would normally be recovered from any award in a court case. Just pausing there, I think that's Tony Newton from memory, who was the Social Security Secretary. Returning to the document, the Chief Secretary and I have agreed that the Department of Health must find the amounts required for the settlement of the negligence cases, perhaps some £3 million to £5 million from within existing provision. The remaining £44 to £46 million would be a charge on the reserve, probably spread between this year and next. As to next steps, I would propose, without directly accepting the Haemophiliacs Council's proposal, to instruct Andrew Collins to ask their counsel to confirm with his clients that they would settle on the basis he has proposed. We must ensure that the settlement figure which has been proposed remains the Haemophiliacs Council's figure and does not become the government's offer, still less the government's opening offer. I will, of course, discuss the tactical handling further with Andrew Collins. I should be grateful for your authority to proceed accordingly. We must expect that news of the negotiation will leak when counsel consults his clients. He would, however, be consulting his clients about a proposal which he himself has made, and I will propose for the time being to make no public comment. If we are asked point blank whether negotiations are taking place, we will propose to say that the plaintiff's representatives have been in touch with us, but that we have no further comment to make. I'm copying this minute to the Chief Secretary, who endorses the approach suggested. We can see it's dated 7th of December 1990. And to conclude this part of the story, we'll look at the Prime Minister's response, which is at HMTR 602_020. As a reminder, this, of course, is John Major. And it says it's directed from the Prime Minister's Private Secretary to the Private Secretary of the Secretary of State for Health, hence Dear Stephen at the start being Mr. Alcock. Haemophiliacs litigation. The Prime Minister was grateful for your Secretary of State's further minute on the 7th of December. He agrees that it is right to settle this as soon as possible for many reasons. He agrees that the Health Secretary should proceed as he proposes, but 1, it must be clear that it is the Plaintiff's Counsel proposals and his figures. And 2, plaintiff's counsel must get agreement from his clients to accept before the government could announce figures. Until then, it's very much plaintiff's counsel's initiative. I'm sending a copy of this letter to Jeremy Hayward, who, as you've said, was your private secretary.
Yeah.
So there we have the Prime Minister agreeing with the proposal, and it was in fact announced the following day by the Prime Minister in the House of Commons on the 11th of December 1990. Just a few general questions about that sequence of events and the arguments lying behind it. You've said that your view on this hadn't changed since your time at the Department of Health. So in effect, Mr. Waldegrave was pushing at an open door.
He was, yes.
And it's also clear from the documents and from your earlier comments that the officials in the Treasury weren't arguing against
No,
that.
no.
Would you agree that the fundamentals against settling the litigation hadn't really changed since your time in the Department of Health? In that, firstly, the legal advice was still that the government had a good chance of winning. Second, there was the risk of setting an unwelcome precedent. And third, in its own right, this was a significant outlay of public money.
No, but yeah, and as I say, people's opinion will differ, both at official level and at ministerial level. You put exactly the reason why I would have done this a lot earlier, but, you know, I didn't rule the world, as dear Harry Seacombe used to say.
But those fundamentals were the same. So what had changed, do you think, in the period between you leaving the Department of Health and you arriving at the Treasury to allow this to go forward?
It dawned on people the impossibility of the government getting involved in all of this in a negative way. And I think people realised it was time to sort this out, dispose of it, deal with it in a way that was fair, and not be frightened of the consequences of taking what some would no doubt continue to regard as a bold step. It never struck me as a bold step. It merely struck me as a sensible step.
Is it fair to say that this isn't a change which is the result of a fine legal analysis? It is a political and moral decision.
Exactly. I mean, I think the legal analysis remains pretty much where it always was. And in fact, I don't remember any changes at all. But yeah, what I always felt right from the beginning, and I think I minuted this quite a lot of months before, is it doesn't matter what happened with the court case. The pressure to do something would continue to mount because the court case was irrelevant to what the public would feel about it. And I just think it was the right thing to do, you know.
Do you remember the issue either being raised with you or being significant in the discussions about settlement? That being the risk of reputational damage either to the NHS or the Department of Health about what had happened in the past.
What, that they didn't want to make concessions because it would have made them look bad.
And also they didn't want to go to court because they didn't want all of this coming out in a public court.
No, I think that, I mean, I agree that there will be people who will think that. I'm not too cynical about what everyone was trying to do. I do genuinely believe that people were in terra incognita. They were in unknown territory when it came to assessing what could best be done about AIDS. You know, remember those heroes at the Sunday Times, they ran a campaign arguing that the HIV virus was not the cause of AIDS. They don't tell you much about that now, but that was quite a celebrated campaign that they ran. So I personally take the view that that there was no reason for anybody to fear what they did as being something. And I mean, in all the arguments I had within the department and with other people, I never said, you know, this will save you from being flayed alive because you failed to take the steps that you should have taken. I think everyone did what they could. But the issue was, once this happened, were we going to say, well, of course, what we couldn't have known any different, not that we got it wrong or that we should have done it better, but that on the evidence that we had, we couldn't have known that this was going to be the consequence. Much better to say, this was the consequence, it's a terrible thing, let's do something about it.
I'm just going to ask you a couple of brief questions about the way in which the announcement was made, because there seems to have been a source of some tension between the Treasury and the Department of Health, and perhaps number 10 over this. It's at 6.1 of your statement.
Yes.
And I'm conscious that we can only ask you about your knowledge of it, and we will, of course, hear from others who are involved in this in due course. But if we could begin by looking at a minute that was sent to you by Jeremy Hayward, your private secretary. It's at HMTR 602_021. And the issue, just so that we're all aware of it in advance, is essentially whether or not the government should make any announcement about the proposed settlement before or after there has been an indication from the plaintiff's side that it is going to be accepted by the plaintiffs. And what Jeremy Hayward, as he then was, wrote to you at the time was this, and it's dated the 11th of December 1990. Haemophiliacs, as I told you, Mr. Waldegrave wants to announce this afternoon.
Yeah, that was the one that was sent, sorry, not meaning to correct you, you're doing brilliantly well with us. This was sent to Norman Lamont as Chancellor.
I'm so sorry, you're quite right. It's sent to the private sector.
A minor matter, yeah.
As I told you, Mr. Waldegrave wants to announce this afternoon that the government has agreed in principle to accept the proposals put forward by the plaintiffs' counsel for an out-of-court settlement. Mr. Waldegrave's office have supplied their proposed text to us, copied to you. Crucially, Mr. Waldegrave apparently wishes to make this announcement whether or not the steering committee of lawyers representing the haemophiliacs has signalled its agreement to council's proposals. The steering committee is meeting council at 1:30 p.m. today. This is, of course, completely at odds with what the Chief Secretary agreed with Mr. Waldegrave last week, and inconsistent too with the Prime Minister's view, Dominic Morris's minute of yesterday. Having discussed this with the Chief Secretary, I've suggested to number 10 of the Department of Health an alternative form of words against the contingency that the steering committee does not agree to the plaintiff's counsel's proposal this afternoon. Quote, I understand that counsel for the haemophiliacs has been discussing with his clients a possible settlement. I welcome that because I believe that the whole House would like to see this matter brought to a satisfactory conclusion. The government will, of course, look to any proposals the plaintiffs may wish to put to us. I cannot comment further at this stage.
Yeah, because as I say in my own note, I was against Waldegrave's initial proposal because, as I say, paragraph 6.1, I considered this to be inadvisable because it's not prudent to announce that agreement has been reached before agreement has in fact been reached.
Yes.
I mean, there was no reason to do that except, I suppose William felt he just wanted to sort of get on with it, and I understand that. Lance as a boil, if it lances a boil a day earlier than might otherwise be lanced, that's fine. But I personally took the view that, you know, good order and discipline means we don't say we've accepted it until agreement has been reached.
Let's just continue in this document, and there's just a couple more paragraphs on the following page. Number 10 thought this was exactly right, so that's the Treasury proposal. The Department of Health did not. Mr. Waldegrave phoned the Chief Secretary on the car phone to make clear his view that a public announcement that the government was prepared to deal would in fact help to secure the steering committee's agreement. The Chief Secretary expressed the contrary view and stressed that it was not in Mr. Waldegrave's own interest to do anything that would increase the risk of the government being driven to accept a more generous settlement. The Treasury had already been more than generous. The Chief Secretary believes that we should now leave this to the Prime Minister's political judgment. I'm fairly confident that Dominic Morris will suggest that the form of words above is more appropriate, unless, of course, the steering committee does agree today with Council's proposed settlement. You can see that's from Mr. Hayward. If we could go back to the first page, please. It's just some marginalia which assists. We can see written in handwriting there, the Prime Minister has now gone along with the Waldegrave proposal and has announced that we are settling. So in essence, a dispute between the Department of Health and the Treasury and you and Mr. Waldegrave about the circumstances.
But he didn't agree with what William Waldegrave wanted to do.
At the time of writing the minute, it seemed that the Prime Minister was on the side of the Treasury.
Yes, exactly.
But subsequently, it appears that he agreed with Mr. Waldegrave. Hence,
Oh, really?
We know that partly through the handwriting and also by the fact that the announcement was made by the Prime Minister later that day. So a dispute, and you've explained your reason for your position. To ask a very broad question, was this a major difference of opinion between Treasury and Department of Health?
No, it's just part of the course, We had far worse fallings out than that. It's inevitable. See, there's tensions in government. There's got to be. Because, and out of that tension, hopefully, comes the right answer. Because, the difficulty of deciding how much money should be spent, and then the difficulty of deciding how that money is divided up between different departments. I mean, this is a tense business. It's impossible not to have frequent fallings out. What we have to try to do is to conduct it in a sort of disciplined way, and there needs to be a sort of bedrock of principle that determines these things, which was why I took the view that, when you've reached a settlement, you say you've reached a settlement. When you haven't reached a settlement, you don't say you've reached a settlement.
Did you have any concerns that taking the approach that Mr. Waldegrave advocated would somehow unfairly bounce individual plaintiffs into accepting the settlement?
I think the whole thing had to have a rhythm of its own. I always felt that one of the best reasons for advocating this was that the proposal came from the plaintiffs' counsel, from they themselves, and inevitably there would be people who wouldn't agree, and I think it was important that those discussions played themselves out rather than people trying to preempt, and there was no reason why, some people wouldn't feel maybe they could have done or should have done a bit better, because of course they were obliged to give up their rights to sue, because you can't settle with someone and still say, but if you want to go and, cost a lot of money, legal aid on one side and government costs on the other, by trying to do better, you couldn't, they had to either accept it or not accept it, but they couldn't have it both ways.
Can I just take you to one further document, please, on this? HMTR 602_023. This is a document I've been asked to bring to your attention. It is a letter that is written by Strawn Heppel from the Department of Health to Mr. Edwards at the Treasury about attaching the press release from the Plaintiffs' Steering Committee. Perhaps, as we look at the last paragraph there, may I repeat what I said on the phone yesterday, that I was very grateful for the Treasury's help in the preparation of the submission to the Prime Minister last Friday, and your forbearance in handling matters yesterday. Perhaps trying to rebuild some bridges there between the Department of Health and the Treasury. If we could just look at the handwriting at the top, please. Now, you can see on the redaction there that there's a set of initials which are covered by that redaction, which is ACJE, which would presumably be Mr. Edwards.
Mr. Edwards, yes.
And he has written to the Private Secretary of the Chief Secretary, so Mr. Hayward. Vexing as the Department of Health's handling of this was, it turned out as well as, or better than, we might have expected. X is encouraging, that's a reference to something in the substance of the document. I will, however, make clear again to the Department of Health that this was no way to do business. In the meantime, I've asked them to ensure that their press office gets across the point that the government has already provided £34 million, brackets £20,000 plus per head. So, first of all, not your handwriting, but that of Mr. Edwards. And he refers to the Department of Health's handling of this as being vexing. Is that a reference to the way in which the announcement was made?
Yes, I think it was just taking up that point that if you reach an agreement, you reach an agreement, but you don't say you've reached an agreement if you haven't reached an agreement. But I think it's a storm in a teacup, really, but stuff happens. I
won't press you any further on that. So I calculate that I have about, I would hope, 25 more minutes questioning of
Well,
Mr.
that
Mellor.
would take us on until 3:45, roughly. It would mean we wouldn't have our usual slightly earlier tea break. It would have this consequence, though, Mr. Mellor, which I need to explain to you, that there has to be a break at a convenient moment in Counsel's questioning, when he's finished his questions, to enable those who are core participants in the inquiry to put through their legal representatives questions they want him to ask of you.
Yeah.
That takes a little bit of time for those questions to be assembled, considered, and so on, about probably half an hour roughly. So that's probably the best time to take the break.
Yes,
So if you're happy to soldier on,
whatever. I mean, you know, I'm very content with your decisions as presiding officer, and I'll abide by what you say.
well, I'm grateful for that, and I trust that the stenographer will bear with us. If he or she needs a break, then they must let us know.
Mr. Mellor, there are a couple of other points about the aftermath of the settlement, but I'm not going to go through with you. One concerns the way in which legal costs were paid, and the argument between you and the Department of Health and Scotland and Wales about how that should be done. That's all set out in Section 6 of your witness statement, and people can see it there. And Section 8 deals with the trust deed for the Mcfarland Trust. I won't ask you in any detail about that, but just this one point. Were you personally, and was the Treasury more generally, to your knowledge, involved in the details of how the settlement was going to be negotiated and the final document that was going to be produced?
Well, I'm sure my officials would have been, but I wasn't myself.
In respect of Scotland, Northern Ireland and Wales, we can see from paragraph 7.2, 7.3 and 7.8 that there was some complaint from your colleagues in Cabinet, Ian Lang for Scotland, and Mr Hunt for Wales, and Mr Brooke, I think it was, for Northern Ireland, that there was insufficient or indeed no prior involvement and prior knowledge on their part about the settlement that was going to be announced.
Well, there's a very simple reason for that. Yap to journalists and God knows what. You know, I mean, this idea that one spreads it all halfway around Whitehall in order that one doesn't offend certain colleagues, and then you read about it in the papers, people say, well, there's been a leak.
A consequence of that, though, was that the litigants in Scotland, who were not represented by the steering committee that had put forward this proposal, had no say in the compromise that was then being presented to them, in effect, as a fait accompli. Was that something that was brought to your attention at the time? Is that a matter that would have rested more with the Department of Health or with the Treasury in terms of considering that?
You know, I'm really, honestly not sure. I think that, I used to find in my 11 years as a minister, you did the big business and then you sort of, like the chef, you leave the kitchen and you leave everyone else to sweep up afterwards. I couldn't really get wound up about any of this, I'm sorry to say. Because you can be absolutely certain that once we sorted that out, there'd have been some other awful problem in another part of the forest. And, the detail of the consequences for the territorial departments, we had officials whose job it was to sort that out. But I hope nobody was too vexed about it. It was a settlement, and a good settlement. But, one thing we were all, everyone, I don't know, it seems to have got quite sloppy these days, but, some of the leaks that we get these days, we've never had in our time because we didn't allow information to flow around as freely as it does today. And leaks can be very damaging. And the most damaging thing, what would have actually blown this out of the water would have been if before it was announced, some of the other groups who wanted to have a similar settlement were told that that the haemophiliacs were getting that sort of settlement. And what that would have done is led, before the announcement of the settlement with the haemophiliacs, others to say, me too. And, that was what caused all the problems when the world was young over diazepam,
I'll move on to the question of transfusion patients.
Where are we now?
We are at paragraph 9.4, or section 9, particularly paragraph 9.4 of your statement, page 56. Now, we will pick up with other witnesses, and in particular Mr. Waldegrave, what happens between December 1990, when the settlement of the HIV litigation is picked up, and December 1991, when a proposal is put to you as Chief Secretary from Mr. Waldegrave about people who did not have haemophilia, but who had been infected with HIV through transfusions of blood or use of blood products or tissue transplants. The document was that first brought this to your attention, so far as we can tell from our record, is DHSC 302921_009.
Yeah.
And this is Mr. Waldegrave writing to you 2nd of December 1991, so about a year after the events we've just been looking at. And what he wrote was this: Dear Chief Secretary, blood transfusions, etc., patients with HIV. After last Thursday's Cabinet, we had a word about the continuing campaign on behalf of non-haemophiliac patients infected by HIV in the course of treatment, blood transfusion, transplant or tissue transfer in this country. I've looked very carefully at this. While I do not think the strength of the case, or indeed its public support, is the same as for the haemophiliacs, there is no doubt that there is considerable sympathy for these unfortunate people, or that a concession on our part would be widely welcomed. By contrast, if we continue to refuse any help, there is a real prospect that the campaign will gather pace and become a damaging and running sore over the next few months. My conclusion is that we should move now to resolve the matter by recognising the needs of these people and their families in the same way as we have recognised those of haemophiliacs. We could do this in one of two ways. First, by giving them the same as we gave to the haemophiliacs and their families in the out-of-court settlement. Second, by also giving them the earlier help provided to haemophiliacs, including, if we can arrange it, access to the original Mcfarland Trust. This help was, in practice, though not formally, taken into account in arriving at the out-of-court settlement. If we take the first approach, the estimated cost is £10 million. The second would cost an estimated £12 million and bring forward the time when the Mcfarland Trust will need topping up. But the cleanest way of resolving this is to go for the second, and I recommend we do that. A clean resolution will also mean detailing with the cases without intrusive a clean resolution will also mean dealing with the cases without intrusive investigation into whether the infection may have arisen in another way. We did not carry out any such investigation with the haemophiliacs, but we will need to carry out some validation of the cases falling into new categories, but only as far as practicable and sensible. Applying those criteria to existing cases would give us about 75 cases which arose in the United Kingdom. The criteria will also mean accepting that there is likely to be a handful of cases in future years who will also be eligible for payment. As to the financing of this, I have already topped up the haemophiliacs money by £3 million because numbers and costs were higher than expected. Nevertheless, I am prepared to pay a third of the £12 million costs. I hope that the other health departments will be able to make a contribution in respect of cases arising in their countries, and that it will be possible for the Treasury to meet the balance from the reserve. I'm copying this to Peter Brook, David Hunt and Ian Lang, who are respectively the Secretaries of State for Northern Ireland, Wales and Scotland. The proposal then is this, is it not, that there's going to be a £12 million cost to Mr. Waldegrave's proposal, that the Department of Health will spend £4 million of it. The other departments will make some contribution, presumably a much smaller one given their size of population, and the balance will be met from the reserve, so up to £8 million subject to how much the territorial departments are willing to put in. We can see that the territorial departments are being involved and consulted on this occasion, but not least because they're being asked to pay as well. First question on this. If there had been no claim on the reserve, would it have been necessary for Mr. Waldegrave to get Treasury approval?
Oh, yes.
Why is that?
Because that's the rule. Just because you've got the money and you could spend it doesn't mean you're able to. If the purpose for which the money was provided is different from the purpose which it's used, then yes, the consent of the Treasury would be required. To that degree, the Treasury reaches its tentacles into everything, really. That's the first rule of Whitehall.
At paragraphs 9.7 and 9.8 of your statement, there's reference to an internal Department of Health document that suggests you had come to some kind of agreement with the Secretary of State. And you thought that was wrong, and that you may have expressed sympathy or suggested that you were open to the idea, but you hadn't actually agreed anything in advance with Mr. Waldegrave.
Yeah, that's par for the course, yes.
If we could just look at HMTR...
Once you never express sympathy with anybody over anything, that's the first rule of being a Treasury Minister, because it's used against you ruthlessly. But let me say straight away, I would love to be able to make a clear distinction between someone who was infected with HIV because of infected blood and someone who got it because the blood provided in the course of an operation or blood transfusion was itself contaminated. I mean, I had no stomach for a fight over that.
You didn't think that was a distinction which could be held?
No. Well, I just didn't. Whether or not it could be justified, and, we've all of us in our different ways made money out of drawing distinctions on the head of a pin, and people have to do it. But morally, what's the distinction? I couldn't see one, you see.
Let me just take you to a document which rather suggests that that you were right to be sceptical of the fact that you had agreed anything with Mr. Waldegrave. It's HMTR 603_041. You can see that this is a copy of the same minute. The version I read to you was taken from the Department of Health files. This is the minute taken from the Treasury files. And we can see that it's got some marginalia handwriting on it, addressed to Mr. Dixon, who is a Treasury official. And it's the initials on that handwriting are JWG, which would seem to be Mr. Grice, another Treasury official. And what Mr. Grice writes is this. Could you put together a submission, please? As you know, there was some confusion about this. Mr. Waldegrave thought that the CST, Chief Secretary to the Treasury, had agreed to this, but that
turns out
not to be the case. Thank you. The Chief Secretary to the Treasury has said that he will look at the arguments sympathetically.
Yeah.
To the point that you were making there, if you say sympathetic, people take it as
But we should be done the courtesy of being allowed to say, yes, we'll do it, not have somebody say, well, you said you were quite in favour of it, so I've just told him you're going to do it. But these tensions notoriously happened with the Department of Health.
Let's look at
and there's probably no harm in it, but, people like to push the envelope, don't they? They like to think they put someone in a position where a half yes becomes a real yes, and then it's impossible for it to turn back into a no.
Let's look at the second point here. Mrs. Firth, who's a Department of Health official, rang me today to say the Department of Health officials' advice had been against the proposal because of the well-known slippery slope towards no-fault compensation. I assured her that we would ensure that the Chief Secretary to the Treasury was fully aware of the potential implications. Is this a little yes minister? As officials in one department unable to persuade their minister of the case, and so turning to officials in a different department to persuade their minister?
That is all part of the course. But at the end of the day, I never really believe in this argument that, if you do this, the skies will open and it will rain for 40 days and 40 nights. The starting point has got to be, what is the right thing to do? I'm I'm sure that if we sat down, we could, between us, find plenty of reasons for a distinction between someone who's acquired HIV through blood transfusion and someone who's acquired it because of treatment that they were receiving for their own pre-existing blood condition. But life's too short, you know.
Just before we move on to your response to this, you said that, I think it was all part of the course was the phrase that you used. So you're not concerned about the fact that officials from the Department of Health were briefing your officials, look, we've told our minister not to agree with this, but he has done it anyway. Is that something?
A fat chance they would have had of persuading me not to do it.
But was that a cause of concern for you at all?
No, because that's what they do. They've got to talk to each other, you know, and they've got to sort of try and get on. And I mean, it's all very stressful and tense, you know. I mean, some of these arguments can be vituperative. So the fact they're plotting in their own way is quite sweet in its sense, isn't it?
Let's turn to your initial response to Mr. Waldegrave. I should say paragraph 9.13 of your statement provides some references to the fact that Ian Lang and David Hunt wrote in support and offered between them £1.1 million towards this. So the Treasury was still being asked for about £7 million from the reserve. The initial advice that you got from your officials, I won't go to it, but it's HMTR 603_043. That advice, and you refer to it at paragraph 9.10 of your witness statement, that advice was to the effect that you should not accede to Mr. Waldegrave's argument. And if we could look, please, at your letter to Mr. Waldegrave, HMTR 603_051. Presumably this letter would have been drafted by officials but would have reflected your overall view at that time, and I stress at that time.
You've got my terrible writing, so yes.
13th of January, I believe that says, Dear William.
Yes, you could be forgiven for not knowing. But as the author of this, it is Dear William, yes.
Thank you. In the letter, you say, thank you for your letter of the 2nd of December. I've also seen the subsequent letters from, now those names have been redacted and they shouldn't have been. They are Ian Lang, Peter Brooke and David Hunt, the Secretaries of State. I understand why you would want to provide compensation for this unfortunate group, and I sympathise. But I also have serious reservations about whether it will be possible realistically to ring-fence any such compensation. There are a range of other groups who have also suffered as a result of treatment under the NHS, where there is no question of negligence. By compensating those acquiring HIV from blood transfusion, we will be taking a further long stride towards no-fault compensation in general. Virginia Bottomley put forward a good defence of our current position in the adjournment debate called by Gavin Strang on the 20th of December. It will be difficult to reverse our policy so soon after that clear statement. But I also have to say that all this is overtaken by the extent of doctors' and dentists' overpayments in the current year. You will appreciate that the latest news about the further overpayments to dentists this year has come as a very unpleasant shock. Your officials have now told mine that the gross overpayment to dentists this year is likely to be a staggering £8,000 per dentist at the very least. That comes to well over £100 million, which you will be looking to me to provide from the reserve. I've also learned from, we could go over, from officials that there will be claims for overpayments this year from Scotland and Wales. It brings the cumulative overpayment to doctors and dentists to over £500 million, more than the total increase many colleagues received in their 1991 survey settlements. In these circumstances, you leave me no room to help you or the other health departments by providing additional access to the reserve for the blood transfusion patients. I cannot therefore agree to what you propose.
Yes, well that, you see, is what has to be done to try and... There are two decisions that always have to be made in all of this. The first is the merits, the second is the affordability. I mean, I always knew they would end up doing it because it was the right thing to do, but that didn't mean one said that. You have to sort of... And I mean, that overpayment to dentists and other people like that was pretty grotesque, so you rub their noses in it and see what they do.
So
we're paying taxpayers' money for these people to play these games on an ongoing, almost hourly basis. that's what they do.
So should we understand this response as being your response that you are not going to agree to paying essentially £7 million from the reserve to fund this scheme, but it's not necessarily saying there shall be no scheme?
Of course. Yeah, I mean, I know it sounds pathetic, but, you know, someone's got to do it. And otherwise you find always I mean, that dentist scheme, I don't think we need to drag ourselves through. It was pretty monstrous, actually, the errors that they made, and someone's got to literally and metaphorically pay for that. But I mean, I can assure you that there was never any likelihood that this wouldn't be done, but there just needed to be a bit of grief along the way.
I'm not going to take you to Mr. Waldegrave's response. It's at
It wasn't very pleasant.
9.16.
Yeah.
No, he pushed back and said that it would be grossly unfair, that's the expression he uses,
unfair.
to use the dentists and doctors as a reason not to fund the proposed settlement that he was putting forward. The reference is WITN 7068010. Further Treasury advice to you, HMTR 603_055. I won't go to it. 9.24 of your statement. But in essence, advising you to retain your current position, but also laying out some options for consideration. Your response to that advice, I will take you to, and it's dated the 5th of February, HMTR 305118_005. And what you, or what was written on your behalf by your private secretary, Mr. Holgate, to Mr. Grice, and we can see copied to a large number of people, including the Chancellor and the Permanent Secretary of the Treasury, Sir Terence Burns. Mr. Waldegrave's current bids on the reserve. The Chief Secretary was grateful for your minute of the 31st of January, which he discussed this afternoon with Mr. Kelly, Mr. Brooke and you. He agreed that the main estimate for Class 13 Vote 1 should be reduced by £12 million to reflect your assessment of NHS Trust debt remuneration, and that the Department of Health should find £8 million towards its accommodation strategy. Those are points that we needn't deal with.
And then we come to the
On blood transfusion patients infected with HIV, the Chief Secretary said that he would be willing to agree to Mr. Waldegrave proceeding with compensation if it was agreed that no further groups would be given similar treatment, and if Mr. Waldegrave found all the necessary funds. So in essence, if he can find the money from the Department of Health's budget, you are not going to prevent him going ahead as long as he can ring fence it. Is that fair?
That's it.
That appears...
And I didn't necessarily mean that, but I think, you know, people can't have easy wins. If you're the Treasury, you have to lose in a tough-minded way, you know. But, I mean, it doesn't alter my view. My view was there was no merit in the distinction between people who got HIV through a conventional operation and people who got it for treatment for a pre-existing blood condition. There was no merit in that distinction, but, you know.
We can see that the Prime Minister met a delegation of MPs on the same day. I'll give you the reference, but we won't go to it. It's CAB 05044_023. Now, am I right in thinking that your response to the Treasury was something that you came to independently of any view that the Prime Minister was expressing to anybody else?
Can you remind what paragraph this is my statement?
The Prime Minister's meeting with a delegation of MPs isn't in your statement. Obviously, you weren't at that meeting.
No.
My question is whether you had come to the view independently.
Oh, of course.
Your position was contrary to the advice that you have received from the Treasury. Is that something that we should be surprised about, or?
No, I mean, look, why are we there? We're there to bring a little bit of judgment to bear. If you're in the hands of your officials, you know, I think I gave you the example of the meeting over, gosh, what's the name of that? Cochlear implants, when I was at the Department of Health, when the strong advice was, oh, you can't agree to that. But, you know, you sort of listened to a chap who'd been made deaf in midlife, listen to what he had to say about the difference. And Jack Ashley was a formidable man that cochlear implants were made to him. And then how could you say, well, I'm not going to do it because it costs $5 million or something? I mean, the only reason for going into politics and doing that kind of job is a little brief opportunity to do what you want to do and hopefully even do the right thing.
I'm very quickly going to just bring the chronology to the end here.
Yeah.
Mr. Waldegrave wrote to the Prime Minister on the 7th of February, seeking support for his position and copying you in. That's HMTR 603_063. On the same day, you wrote to Mr. Waldegrave, this is the 7th of February again, it's CABO 5044_024, paragraph 9.32 of your statement.
I got that.
In effect, saying what you've said to your officials, to Mr. Waldegrave. The Prime Minister's private secretary minuted on the 10th of February, and it's HMTR 603_067, 9.34 of your statement, in which he expressed his hope for an agreement, which seems to be, and please correct me if I'm wrong, but a prime ministerial hint that there should be a compromise on both sides on this to allow something to go forward. Mr. Waldegrave then responded in DHSC 402582_003, page 9.36 of your statement, in which he addressed the point raised by you and the Prime Minister about ring fencing, and said that he thought that the position covering all of those infected by HIV by NHS treatment, so people with haemophilia and people who didn't have haemophilia, would be more defensible than the existing position, not claiming that it would be absolutely defensible, but more defensible. And that was on the 12th of February 1992. And on the 14th of February 1992, 9.37 of your statement, the reference is CABO 5044_030. You wrote to Mr. Waldegrave accepting his judgment about the borderline being drawn, noting that he would find the funding himself, so wouldn't draw on the reserve, and in that those two conditions being in place, agreeing then to the £12 million scheme going ahead. Now, we've rattled through that at quite a pace. One point that arises out of that is, why was it that you accepted the assurance that Mr. Waldegrave gave that in his judgment the position would be more defensible in terms of ring fencing?
I think it probably would have been. I actually agreed with that. I mean, because it's the mirror image of the point I made earlier. You know, if you get HIV because of a blood transfusion, if you get HIV because of treatment for your blood disease, there's no real difference between the two. So if you try and draw a distinction between the two, it doesn't strengthen either the government's reputation for consistency of purpose, but it also just makes the government look as though it's got no real moral authority on any of these things. You know, that was my view.
One final question on this. All of this was taking place shortly before the general election, which was held on the 9th of April 1992. You were asked by the inquiry, when preparing your written statement, what effect or what role the election played in any of these decisions. And your answer was the single word, none.
Yeah.
Why are you so emphatic that electoral considerations weren't part of this?
Because, I mean, elections are determined by far bigger things than this. This is a big thing, but you aren't going to change a lot of votes because of a decision made about whether or not you pay compensation to people who've sadly obtained the AIDS virus from a blood transfusion as against from a blood disease. There aren't very many things that move the dial, and this certainly wasn't one of them.
After that election, you left your role as Chief Secretary to become Secretary of State of the Department of National Heritage, the so-called Ministry of Fun, I think was the aphorism of the time. And am I right in thinking that thereafter you had no further role in any matters relevant to this inquiry? Mr. Mellor, those are the questions that I have for you. As the Chair said, there will now be an opportunity for call participants to put forward questions to us.
Sure.
And I'm sure the Chair will allow a break as well.
So how long do you expect you may need? About half an hour?
Could I ask for half an hour and...
So not before 4:20.
Yeah.
Not before 4:20.